You are scrolling online, maybe looking for a new pair of shoes. A few minutes later, you open a different app, and there they are, ads for those exact shoes following you. It feels like someone is listening. This unsettling reality pushed a group of ordinary citizens in California to do something extraordinary. They were not politicians or lobbyists. They were a privacy group called Californians for Consumer Privacy. And they kickstarted a revolution with a simple ballot proposition. The group gathered enough signatures to put their stringent privacy initiative on the November 2018 ballot. This sent shockwaves through Sacramento and Silicon Valley. In California, a voter-pass proposition is incredibly difficult for the legislature to change. Fearing an inflexible and permanent law, state legislators entered a high-stakes negotiation. The deal was simple: pass our slightly less restrictive version of the law, Assembly Bill 375, and the activists would withdraw their ballot measure. On June 28, 2018, the deal was struck, and the California Consumer Privacy Act, or CCPA, was born. So what did this 11th-hour political bargain actually give people? It established a foundational set of digital rights for every California resident. The right to know exactly what personal data a business has collected about you. The right to know if that data is being sold and to whom. The right to access a copy of it. And most critically, the right to tell that business to delete it all. For the first time, the law also explicitly forbids companies from discriminating against you, say, by charging you a higher price, just for exercising these new rights. The law's power lies in its incredibly broad definition of personal information. It is not just your name, address, or social security number. It is your IP address, your email, your search history, and your geolocation data. It even includes biometric information and any inferences a company might draw from your data to create a profile about your preferences, characteristics, or behaviors. This is the bedrock of how modern AI and advertising algorithms work, and the CCPA puts it directly under the consumer's control. One of the most visible results of the CCPA is a small link that now appears on countless websites. It says, "Do not sell my personal information." This is not just a polite suggestion. It is a legally mandated command. Businesses must provide this clear pathway for users to opt out of the sale of their data. For minors, the rules are even stricter. Companies need affirmative consent from a parent for anyone under 13, and from the teen themselves if they are between 13 and 16, before they can sell their data. You might think this only applies to tech giants headquartered in Cupertino or Mountain View, but the law's reach is vast. A business falls under the CCPA if it simply does business in California and meets at least one of three thresholds. It has annual gross revenues over $25 million. It buys or sells the personal information of 100,000 or more California consumers, or it earns more than half of its annual revenue from selling that data. This means a retailer in another country that ships products to California is on the hook, effectively setting a national and even international standard. To make sure companies take this seriously, the law comes with significant financial penalties. The California Attorney General can levy fines of up to $2,500 for each unintentional violation, but if a violation is found to be intentional, that fine skyrockets to $7,500. A single violation can apply to every single user whose rights were infringed. When you consider that, the potential costs for a non-compliant company become astronomical very quickly. Perhaps the most potent tool the CCPA provides is the private right of action for data breaches. If a company fails to implement and maintain reasonable security procedures and your personal information is stolen, you and others can join a class action lawsuit. The law allows for statutory damages between $100 and $750 per consumer, per incident, or actual damages, whichever is greater. This is a game changer, giving individuals the power to hold corporations directly accountable in court for failing to protect their data. The CCPA was never just about California. It set off a chain reaction across the country. Other states, not wanting to be left behind, started drafting their own versions. Virginia passed its Consumer Data Protection Act, but with a key difference. It is only enforced by the state's attorney general, lacking the private right of action that gives California's law so much power. This created a complex patchwork of regulations. It also forced a national debate on whether the United States needs a single federal privacy standard to rival Europe's GDPR. The activists and voters in California were not done. In 2020, they went back to the ballot box with Proposition 24, also known as the California Privacy Rights Act, or CPRA. It passed, expanding and strengthening the original CCPA. It also created a brand new government body, the California Privacy Protection Agency. Its sole purpose is to enforce these rules. This move showed that the fight for data rights is not a single event but an ongoing struggle. It is constantly adapting to the challenges posed by new technologies like generative AI.